our lovely colleagues. My name is Sid Freeman. I am the president of WiCCD. WiCCD is Canada's first national advocacy organization solely for women, those who identify as female or gender nonconforming, who work in the area of criminal defense. WiCCD is absolutely delighted to co-host this very special event with LAMDA. We share LAMDA's commitment to supporting our members and the communities we serve. A large part of that commitment is expressed through CPDs, such as the one that we are gathered here for tonight. The incredible, very talented panel assembled for this event has much wisdom to impart to us, and I have no doubt we will all leave here enriched by the experience. I thank those involved in organizing this event. You have done yourselves proud. And my thanks as well to the panelists. Thank you for giving us your time and expertise tonight. Anita, I turn the floor over to you.
Thank you, Sid. Good evening, everyone. Thank you so much for attending this event on representing Inuit clients in the criminal justice system. My name is Anita Sigeti, and I'm the president of LAMDA, the Law and Mental Disorder Association. LAMDA is a national organization of 200 lawyers and law students who represent clients with serious mental health issues in civil and criminal justice systems. We are proud to co-host with WiCCD and very proud to present this program. We too are honored to have such esteemed speakers on this panel, including, of course, Nunavut MP Lori Idlout. I've been a member of the Nunavut Bar since 2014. I've represented NCR and unfit accused before the Nunavut Review Board. I have noted that justice system participants have very little knowledge or awareness of the unique needs and heritage of Inuit clients, which is why this special and unprecedented event is so sorely needed. Before we move on to introductions of the speakers on the panel, it falls to me to address the exciting housekeeping issues. First of all, this event is accredited by the Law Society of Ontario for 1.5 hours of the coveted and hard to get EDI professionalism hours. Second, as you will have seen, this event is recorded. The recording will be made available on request only, and only to those who attended or registered. Finally, at the end of the evening, we will ask those of you who are able to turn on your videos so we can take a couple of group photos for use on social media and to commemorate this online event. Last but not least, I also want to thank not only our accomplished panelists, but in particular, Naomi, organizing committee for this event. Their bios are included in the registration information you've received, so I won't go through them, but they are both leaders in the profession and hugely knowledgeable about legal issues affecting Indigenous clients. With that, I hand the evening over to Naomi and Jay.
Awesome. Thank you so much for the introduction. Thank you everybody for being here. I'm just going to do a short land acknowledgement, and then we're just going to have a brief moment of silence for the James Smith Cree Nation. It will be about 1 minute long, and then I'll go into short biographies of the panelists and just introductions, and then we'll get into their introductions, questions, and discussions flowing from that. So I'm going to change my name to a website. You can use this website to find your own territory and for your own resource when you're doing your own land acknowledgement. Okay. So the territory that I'm located on is my traditional territory of the Anishinaabe, the Robinson Huron Treaties. I am proud to be a member of this nation and honored to be here. I also like to just acknowledge our Inuit brothers, sisters, and kin who may have been displaced throughout Canada as a result of criminalization and displacement of movement through institutions, which often happens from Nunavut to Ottawa and larger city centers, generally not Sault Ste. Marie, where I'm currently located. So given the issues that are happening facing Indigenous nations right now, particularly James Smith Cree Nation, we would like to just have a brief moment of silence for 1 minute, and you can choose to turn your screen off. You can choose, mute yourself, and however you want to use that 1 minute. Starting now. Thank you. Okay. So our panel members, I'm going to start off with just a brief introduction. So MP Lori Idlout, she is you can rearrange your screens to just have the speakers present or up at the top. So if that's what you wish to do, you can, but generally whoever's speaking will be on the first page. So if you're having trouble finding the speakers, but Lori Idlout is MP of the riding of Nunavut in the House of in federal Parliament. She's a member of the NDP. Before her election, she practiced law in Iqaluit with her own firm, Kisqueca Law. She represented the group protesting against the Baffin Island iron mines, as well as serving technical advisor to the Iqaluit hunters and trappers organizations during a public hearing on the issue. Her bio is in the materials as well. Eva Taché-Green, I'm sorry, is did I say that right, Eva?
Yeah, no, that's fine. It's Eva Taché-Green. Thank you.
Thank you. I'm sorry. Is an appellate lawyer with Nunavut Legal Aid. She is a director at the Nunavut Law Foundation. Due to her extensive background in nonprofit work. She also has practiced criminal defense law for nearly 8 years, and most recently as defense counsel and appeals coordinator for the Legal Services Board of Nunavut. And Mallory Malone, she is a criminal defense lawyer working with Legal Aid Commission of the Northwest Territories, where she maintains an active trial practice as part of the Northwest Territories Comprehensive Legal Aid Program. She travels throughout the communities within the Nunavut settlement region. I'm sorry. And travels along circuit courts up there. I'm sorry, my computer screens was cutting the bios off for some reason. Okay, so we'll get into brief introductions from the speakers themselves, little notes that they would like to say, and then we'll get into the first round of questions in terms of the CPD program. So if we want to start off with MP Idlout. Lori?
Naomi Amaro ilonase inuktu pigiago mayunga ikping nere katao nere sir kanutigi tukisi yaungitige katang mga sille maligaleriyo tidlusi kigaktu tidlusi inungnit takwa kigaktuk tassi iliksinni tukisingiksu yaktuksaw katang mata tekane ikkaktu yo karangami aksorong naktukko katang mata tana sakyago tigi masakara. Thank you so much, Naomi, for the introduction. It's good to see you again since law school at the University of Ottawa, and it's good to see Caroline as well. We studied together. I wanted to start my introduction in Inuktitut and speak as long as I can in Inuktitut, just as a way to symbolize what your clients go through. Many of the people that are going through the justice system in Nunavut are mainly Inuits, Inuktitut speaking, and don't have very strong English speaking skills. So I think a lot of the times they might struggle to understand what's going on in the system. And I really wanted to just show how much language plays in the justice system, and what the lack of interpretation can feel like for your clients. So that's how I just thought I'd introduce myself very quickly. After having graduated from law school at the University of Ottawa, I very I articled, I had 3 different placements in Iqaluit, which I learned had so much about. I did only a little bit of criminal law at the Nunavut Court of Justice where I clerked. And I only had basically 1 client in the criminal justice system before I became a member of parliament. But I'm hoping that my experience as a Nunavut and having gone through law school and being part of the Nunavut bar will still be helpful for today's CPD, which I think is so important. So,
thank you. And Eva?
Thank you. I want to start by saying kanami to Lori. It was really wonderful to hear you speak in Inuktitut, and I really appreciate your decision to do that and what that shares with everybody participating this evening, because I cannot agree with you more that the experience of going through the justice system in English as an Inuktitut speaker must be very alienating, and I experienced that with my clients. I've been a guest in Nunavut for 3 years, so I consider myself still very naive about the ways of the North, but I try to learn every day, and I'm happy to have an opportunity to share with you all some of my experiences and thoughts on representing Inuit clients in the North, and hopefully that can also shed some light on what it might be like to represent Inuit clients in the rest of Canada as well, if that happens to be part of your practice. Thank you.
Thank you. And Mallory?
Hi there. As Naomi said in the brief intro, I'm currently residing in Yellowknife in the Northwest Territories. I work for Legal Aid, which as I mentioned, it's a comprehensive legal service entity here in the Northwest Territories, where we serve clients in Yellowknife, but we also serve clients in 36 communities throughout the Northwest Territories. I've been here for just over 2 years at this point, but my circuit assignments have primarily been in the Beaufort Delta. And so that covers the 6 communities in the Nunavut regional settlement. So I have some experience, but as Eva says, I also appreciate more and more as time goes on that there's a lot of learning to do when you're doing this work. And I continue to benefit from my clients' generosity when they share with me their experiences, and the more I learn about my clients and about Inuvialuit culture, specifically in the Northwest Territories, the better I serve them.
Amazing. Thank you for the introduction, everyone, from your work and just a little bit about what you do. So I'll get right into the first rounds of questioning. The questions could be, as Eva outlined, practicing in smaller communities, but I think it's important to highlight the context for extremely northern communities, duty to maintain confidentiality, justified and permitted disclosure, including those discussions with clients. So in the context of your work, we'll start off with so we'll go backwards this time, Mallory. Some of the unique challenges that working in smaller communities like Inuit communities a practitioner might encounter in terms of confidentiality and privilege. And then there's a second part of that question. If you want to think about that in your answer, there may be some discussions of harm and safety of person to self, and so what some of those discussions might look like in terms of justified or permitted disclosure, and what kind of tools or resources do you use?
Well, in a general sense, one of the difficulties that we encounter on circuit is that we are setting up court in the largest building that the community often has, and those aren't very big buildings to begin with, and so it's a challenge to meet with clients in a confidential setting. It's literally often broom closets or the emptiest stairwell that we can find. And so we have to really be mindful that the client's perspective and how private these conversations are in these ad hoc meeting spaces. We want our clients to feel comfortable and also be able to have a space. So sometimes that's being very firm with the sheriff who is on circuit with us that we need to find a space. Can you get in contact with, the person who operates this building? Can we get a key to this kitchenette area? So that's a challenge just in being able to speak with clients. Another challenge that arises is communities can be very, very small. And so if you're encountering a file that has a number of witnesses, you are going to immediately start having to be very attenuated to the relationships between everyone and how conflicts can have to be managed. That may involve having to advocate for another counsel being assigned to your circuit so that you can provide independent legal advice for everyone in a file. In terms of confidentiality, another challenge we have is that we have very little time in the community. So those tiny meetings that we have in broom closets, ideally you'd like to have longer telephone conversations with clients, but you have to also be aware that clients often have sporadic access to telephones or may not have a telephone at all. So we often have to be very clear with our clients when we first speak with them that we're going to need to have a few phone numbers that we can try and get messages through, or maybe contact your aunt or contact your grandmother, or have a way to get a message to you. But you want to be clear with the client that you're going to be calling and saying that you're from legal aid, and that might be a problem for them if they don't want anyone in their family or their community to know that they're having to use legal aid services. So those are a couple ways that confidentiality becomes an issue in this practice.
And just moving backwards, and Eva, did you want me to repeat the question?
I have the questions actually just printed out next to me, so I am looking at them, and I'd like to, of course, echo a lot of what Mallory said. The work that we do in Nunavut is, I think I've never practiced in NWT, but I imagine it's not dissimilar in the sense that when we are on circuit, we fly into small communities shortly before court begins. And it doesn't give us a lot of time to connect with our clients, which does raise issues of confidentiality and meeting location. Certainly broom closets are not an unusual place to have a meeting. But more often than that, I find that I meet my clients in my hotel room the night before or the weekend before. And there are issues about meeting clients in a hotel room. Often the court party is also staying in that hotel room. Often there might be policies at the hotel that block people coming in. So those are all challenges that we face in trying to find private places to have these conversations, and certainly means of communicating outside of face-to-face meetings are exacerbated by lack of access to continuous telephone or internet access. I just wanted to add to that though, and I'm not sure if this is the case in NWT, but we also have trouble here in Iqaluit with accessing private communication with our clients who are in custody. We have a new jail in Iqaluit, which is opened last year, and it doesn't have a lawyer meeting space. So when you go to meet your client at the jail, you're sort of in the main public area where anybody else might be. With special, dispensations, you can get access to a private room, but there seems to be a default sense that it's okay to talk about whatever private or serious matter you're meeting your client to discuss in a sort of very public forum. And I find that to be quite disturbing. And from what I understand, it's also nearly impossible for clients who are on the range to access a private place to make a telephone call. So, there's a bunch of ways in which our ability to build that trust relationship, which is so fundamental to the relationship of representing folks, that trust relationship depends on that confidentiality, and we don't always have access to that for all sorts of structural reasons. And if I might, I wanted to just turn to your next question, which was about discussions of harm and safety to other persons or self, if I'm looking at it and reading it correctly. And, I wanted to just share some ideas about how we creatively come up with tools for helping folks that we think might be vulnerable in remote communities where there are so few services available. And I know later on we'll talk more about what services are and are not available. But one example that I thought of that is perhaps not obvious to people who don't practice here is that if we are arranging release conditions for somebody to be released on bail or crafting probation conditions, we will often make a point of preserving the opportunity to go on the land and participate in hunting activities. So it's not at all uncommon, for example, to have access to firearms while you are on bail or on probation, as long as that is, because you're on the land hunting and that your curfew or bail conditions will allow you to stay out overnight for camping. And because of the connection between access to the land and participation in those activities and mental health and well-being, it's like so obvious to so many of us who live and work up here. The court is usually quite open to that. And I was sort of trying to imagine if that would be something that would exist in other parts of the country. And so I just wanted to share that as perhaps a concrete example of how there are things that we can do as lawyers, even with all these restrictions on what's available to help our clients look after themselves and participate in their culture.
Thank you. And Lori, did you want me to repeat the question for your reference?
No, I've got the questions on my screen as well. I think Eva and Mallory has done a really good job describing the realities of being the defense lawyer. And I think just a few other things about confidentiality. I think it is very challenging because there's a gap in the Nunavut communities, in that Nunavut Legal Aid does not have offices in every community. So it's really hard for lawyers to meet with their clients beforehand. So having to try and figure out how to meet with your clients. I think hotels are not the most secure place, but there are places in every community that you might want your offices to try and coordinate with. Like every community has either government liaison officers from within Inuit organizations like Qikiqtani Inuit Association or Kivadlik Inuit Association. There are organizations in Nunavut that have offices in every Nunavut community. So trying to figure out how you can access those, because there's not really any other way to make sure that you can find your clients, because it can be quite challenging with many of them not having phone numbers or cell phones. Another interesting tool to use is Facebook. Everyone has Facebook, So it might be useful to try and find your clients through Facebook without I know that there are concerns with confidentiality, but when it comes to making sure that you have the time that, because your time in the communities will be so brief, that you have to do as much preparation before you actually go in, because most of your time will be in court with very little time to actually meet with your client to argue their case. So I just wanted to finally add very quickly to also be careful when you're with your clients, because I've seen incidences where the Crown and the defense lawyers are seen to be socializing, and that can be a big no-no, especially in the communities. When there's already a huge lack of trust in the justice system, but that's something that you'll have to learn to gauge when you're actually in the communities, because some of them might actually like it better if you're able to see that the Crown and the defense lawyers are willing to work together for the best interest of the person that is going through the justice system for each case. I hope that's helpful.
Yeah, that's very helpful, especially the relationship with the Crown. Sometimes they seem very adversarial outside of smaller communities. So there is a second question on managing conflicts of interest. So I just know sometimes when I try to explain it to clients, particularly my Indigenous clients, it sometimes seems theoretical to them and they don't grasp it. And so I'm constantly looking for ways to explore how do I explain and manage these conflicts. So I wanted to ask how in your work in smaller communities, how do you manage conflict checks and how do you communicate these to clients? Are there special tools you use to help the client to understand this duty, and what does that look like? And we'll go with Lori and then work our way back.
I think it's really important to figure out the kinship terms, because if one of the clients has a sister-in-law, there's a specific word depending on whether it's on the mother's side or the father's side. So it's very important, I think, that you get specific instructions on how to learn what those kinship terms are, because that also becomes quite important when you're arguing in court. You have to listen for it. It's easier when you have interpreters, but making sure that while you're preparing, it's really important just to make sure that you learn the kinship terms, and then to just, it's difficult because the more Nunavut there are, or the more Inuit there are, the more frequency of similar last names. So even myself, I was asked if I was related to a different Idlout, and there was no relation, so there was no chance of conflict. But it's good to always ask when people share the same last names, not just to assume that they're related, but just to make sure that when you're potentially representing a client who might have conflict with another case, it's very important always to ask. I think it's just the first thing that you should ask if there are family relations and how distant the relations might be to other people. That's the best way that I guess I can try and be helpful. But the biggest one is to find ways to make sure that you understand kinship in the communities.
I like that important reference back to kinship. And Eva.
Yeah, I think that's super interesting what Lori just shared with us. And it's complicated for us, all sorts of reasons. a lot of Inuktitut names or Inuit names are transliterated into English with different spellings. So you can have sort of what Lori said, but then also the opposite. You can have two people who have different spellings in English, but are in fact related because they have the same last name. You also have a phenomenon, as far as I understand it, it's very common for Nunavummiut to have their mother's last name. And so the assumptions that we make about paternal names being the ones that are connected, you have to really know what you're doing before you start making assumptions about people's names. And that's so essential to conflict checks. One of the things, Mallory and I were talking about this earlier today, about how to manage conflicts within a small community when you have lawyers coming in, and there's this sort of balance between being an outsider who knows absolutely nothing about the community coming in and sort of putting your foot in your mouth all the time around not understanding the relationships between people in that community, who is related to who is common law with who, and then you have complainants and accused sort of on cross cases, and keeping track of all of that is something that comes with time and familiarity with the community. But then the longer you go to the same community, the more you become conflicted out of being able to represent people on the docket, because you have by that time represented so many of the people on the docket. And I hope I'm not taking, Mallory, what you were planning on saying, but I think it's really important to figure out that balance. I know in legal aid in Nunavut, we tend to have staff lawyers assigned to communities for about 12 months. And then after that, they might be switched to a different community. And that seems to work okay. But when we have the situation of bringing in a panel lawyer to a community they've never been to before, it's really unlikely that they'll be able to figure it out in the 3 days that they're there. And I think that could be quite a problem. I also wanted to flag, if it's all right with you, some other sort of areas of conflict that arise, just sort of outside of our standard thinking around conflict checks. We have, different ideas about what conflicts are. And I think it was already alluded to by Lori that there is this very deep-rooted distrust of the legal system, particularly with respect to defense lawyers and Crown being separate entities. I think that's quite hard for a lot of people to appreciate, because everyone flies in together. And so I personally think, and I think organizationally, we think that it is important to maintain that distance from the Crown and the court, to make it very clear that we are, your lawyer, that we are defense lawyers, and we're not part of the court system. It's not at all uncommon to have clients say, well, you're just a Crown. And the tricky thing is that in such a small jurisdiction like Nunavut, we do in fact have a lot of defense lawyers who do become Crowns. And then we have a lot of Crowns who become judges. And so we have this very small bar, this very small community, and the perception of a conflict of interest is in fact very real, because we do have the same people playing all these different roles. And I think I don't have an answer to that. I just think it's something that's worth flagging, because it is, I think, quite problematic. And it's important as defense counsel to be very clear about where you stand. And, it's just as an example, we had an issue that arose today. There's a new justice of the peace in Nunavut who might be presiding over a trial where she was counsel on that very same file not more than 3 weeks ago. And that's not even an unusual situation here, but it obviously that doesn't work. We can't have a situation like that, but there's so few people that the potential for that sort of conflict is high. And what I think is the biggest risk of that is a loss of trust in the relationship between defense counsel and the client. So that's the biggest casualty in my view.
Thank you. And Mallory?
So yeah, as Eva and I were talking about this earlier today, another thought I had was I started this role with a very specific belief and understanding about what a conflict of interest is. And that has had to kind of modulate through time and through the different circumstances that I might find myself. Because if we had an absolutist approach to conflicts of interest here, we would often have clients without counsel. And so one tool, interestingly, that we kind of use is when it's close to the line of a conflict, is simply asking the client whether they feel that this is a disloyal situation, and if they're comfortable moving forward, and then also reviewing the witness list immediately with a client to say, who is this person, where do they live, how well do you know them, and what's the relationship. That's one way of doing a conflict check. In our office here, Legal Aid Northwest Territories is divided into 3 separate clinics. We're all on the same floor in the same building, but we function as though we are independent law firms, essentially. And so we all keep our own conflict cards, and before a circuit, we do run through the list, and the assigned like the lead counsel for the circuit is given a heads up as to what our conflicts would be. And so that would be another tool we use. And then further to Eva's point, a related conflict that can kind of come up is when a client is feeling frustrated with the system, or frustrated with how long things are taking, or the Crown's position, or something like that. And so they can sometimes accuse defense counsel of just being a Crown, or just being part of the system. And so in my practice in Ontario, I might have said, well, I think this is a breakdown in our relationship, but there seems to be some questions about my loyalty here. I better take a step back. That, again, only works when you have numerous other counsel that you can refer your client to. So there is a lot of effort to resolve any issues that come up on the basis of the perception of our role in the system. But understandably, a lot of clients have a deep mistrust, and so sometimes a conflict of interest arises where it's just the client's perception, and that can't be overcome.
Thank you. Really important points about how to manage, especially in comparison to Ontario, where there's lots of counsel and not a whole lot of counsel up north. So I'm just gonna redo the order, so I'm not just going back and forth. So I'm gonna start with Eva, and then we'll do Lori and Mallory. And the second round of questions here, we're doing good for timing. So I just want you to know that I'm keeping track of timing, and I will assist with that. So the second question goes to recognizing and being sensitive to client circumstances, special needs, and intellectual capacity, as well as gender, socioeconomic status, demeanor. So in smaller communities, what are some of the challenges that practitioners should be aware of when represent Inuit clients? And so thinking about the broader context, so cases that are coming down are Risha Sharma on conditional sentence orders, the recent Pope's visit, like how that impacts our clients, and obviously the most recent one, James Smith, how that impacts our clients and those close-knit communities. And then also how to discuss the needs of Inuit clients in other respects in compared to other Indigenous peoples. Generally speaking, First Nations and Métis, and to discuss the unique challenges representing the interests of Inuit clients as counsel or an advocate in Parliament. And then we'll move to the second question after that. Eva.
That was so many questions.
They're not really questions, more like discussion points, like just context. So like,
I'll just run with it. And if there, yeah, I'm happy to I'm happy to take a, to try to answer some of that or address some of those really interesting discussion points that you raised. I've never practiced in small communities outside of Nunavut, so I don't know whether Inuit small communities are different from other small communities, or in particular other Indigenous communities in Canada. I was listening to a radio report about somebody who had gone to the James Smith Nation and was describing what it looked like. And it seemed sort of familiar to some of the things that I observe when I go into small communities in Nunavut, but of course I've never had those experiences, so I can't really speak comparatively. I think representing Inuit clients, I have a couple of sort of just general ideas about just to flag some of the differences between representing Inuit clients and perhaps other clients just broadly, because it is a unique client base, and it is, I don't think, wise to try to oversimplify the experiences of Inuit in the North, the experiences of Inuit anywhere in Canada, or to try to smush that into the experiences of any other Indigenous group. But and also, even within Nunavut, every community is different. Every one of the 25 communities are distinct, have linguistic differences, cultural differences, historic differences, which really comes into play when talking about Gladue principles writ large and how those might come out in any given case. But yeah, I wanted to give everybody a couple of just like really concrete examples. So, when you're a defense lawyer and you are cross-examining somebody or examining your witness in chief, and you try to get them to situate when something happened, that can be really hard to do in a place with 24-hour daylight or 24-hour darkness. And so, there's these really sort of basic questions that lawyers fall back on. Well, what time of day was it? Well, you don't remember, but what was the light outside? And, frankly, if there's 24 hours of sunlight, you are probably not keeping track of whether it's noon, 4 o'clock, or 4 a.m. And so that's one of those things that you have to remember when you're both, examining or interviewing your client, and also when you're in trial. Another example, and I don't want to generalize too much, but this is an experience that I've come across a lot, is that there's it's quite rare in my experience anyway, and I'm happy to be corrected, for doors to be locked. There is a reason why doors aren't locked in small communities in the Arctic, because you might need to get to safety in a blizzard. And so the idea of, private property, this is my house, my castle, here is my locked door, doesn't necessarily work the same way. And so that comes up in cases of break and enter or unlawfully in a dwelling place, where you might, make these assumptions about being invited into a space. And those assumptions might not be good assumptions to make in the context of Northern communities. And then the other one that I wanted to flag, and this may be true for folks in any small community, but when you have a situation with the justice system essentially flying in once every few months, and that court comes in and imposes conditions like no contact conditions, no-go conditions, well, good luck with a real no contact condition when the person lives next door to you. And even if they don't live next door to you, chances are pretty high that they live close by, because it's a small town. And so a lot of those assumptions about, well, how come you breached that? How could you have breached it? You knew you weren't supposed to. Well, it's really hard to get around without running into that person. And more so if you have a situation where you have a no contact with a spouse or a family member. Nunavut has a devastating housing crisis. The shortage of housing in Nunavut is, it's hard to even put into words. And so the idea that you could put in a no contact provision for people who may have really literally no choice but to live in the same place, and like you can't be outside. So it's just so impractical to put in those types of conditions in a lot of situations. And so just remembering that the lived reality of people is so different from the assumptions that we make in the South. And I think that a lot of our kind of fallback criminal justice tools rely on these assumptions, and they don't apply in a lot of places in Nunavut. So I'm not sure if those really answered your questions, but I just wanted to kind of open it up with some of those examples, and I'm happy to jump back in with more thoughts on some of the other things that you brought up, Naomi. Thank you.
Absolutely. Those are all really important points. And I can't remember the order that I said I was going to go in, so I'm going to go to Lori.
Thank you, Payanami. The first thing that came to my mind to respond is that lawyers need to be trauma informed, because a lot of the clients that you'll be exposed to ultimately most likely will have experienced trauma in their lives. Probably, I don't like to generalize, but probably 100% of the times they'll have been traumatized by a very colonial system, and taking trauma-informed cases, I think, is very important. Being aware of the historical treatment of how Inuit were treated in all of Canada, how First Nations Métis have been treated in Canada, how their identities were attempted to be stolen through very aggressive means, and that intergenerational trauma still exists, and that intergenerational trauma is still being passed to our grandchildren. And it's so sad to see, but it's still very, very real in many of the Nunavut communities. Many of the communities as well don't have GLADU reporters, so most likely you're not going to be able to rely on a GLADU report. So you might want to familiarize yourself with how you could use that as a tool in your own practice, because most likely JPs or judges will not order them. But if that's something that you want to rely on, that's something that you'll have to initiate yourself. Eva touched it on this briefly as well about overcrowded housing situation. It really is that bad. I remember when I was articling, I was sitting in a child welfare case, and a grandmother chose, instead of having her son become homeless because of the conditions imposed on him through the criminal justice system, chose to have her son live with him and have her grandchild be sent to the other grandparents, because she preferred that he's not sent out in the streets in the dead of winter. So you really do have to be quite careful with the conditions that you want to recommend to the judges, because it's not just cultural, it's not just how difficult it is. It can be life or death situation that you're putting them in when you're suggesting conditions as no contact, especially when most communities are so small. Most communities don't have shelters. Most communities don't have facilities for the alternate places that many people can't go to. Places like Iqaluit and Rankin, they're becoming quite overwhelmed with people who've gone through the justice system, and it's just not the best way to make sure that there's deterrence. So being careful about what you recommend is quite important. And I think there are some safe things to assume that can be generalized a little bit, but I don't recommend generalizing a whole lot. Most likely your clients will prefer always to speak in Inuktitut if they had the choice to, but they will say that they understand English. But always be careful with how you ask your questions, because we're not very good with double negatives. So if you ask double negative questions, you might get a different response that's not the fact, but it's because of the misunderstanding. Those double negatives could have a huge impact on your case. So always be very clear in your language, yes or no, like very clearly making sure that you're asking Inuit have facial expressions that they've always used. Yes for raising your eyebrows, and naksuk, I don't know how to say naks, scratching your nose for no. So when you think about that as a basic example, the way that we communicate in Inuktitut is clear. So remember that when you're arguing for your clients, to try and be as clear as possible, especially when it comes to examining and cross-examining is probably a lot more difficult. So those were just things that I wanted to share quickly, and those different kinds of questions that you had asked.
Sorry, Mallory.
Those were all really incredible insights, and thank you particularly, Lori, for highlighting the importance of knowing the history before you walk into a community, because history is not that distant from the communities, particularly for the communities in the Northwest Territories. I can't speak about Nunavut because I haven't practiced there, but the communities that we go to have not been established for very long. They've been gathering spaces and occasional seasonal living spaces for thousands of years, but in terms of being permanent communities, that is from about the 50s, 1950s. So this is a history that a lot of our clients are living in and see on a daily basis. It's within their grandparents' generation that forced settlement has happened. And to that end, there are a lot of good resources to learn that and put some effort in before you walk into the communities. For example, the Northwest Territories last year released a program that's available online for free called An Introduction to Living Well Together. And that goes over the history of colonization in the Northwest Territories. It covers all of the Northwest Territories. So there's a number of different Indigenous people who live in the Northwest Territories, but if you're looking for information about the experience of Inuvialuit people, it's really helpful. So remembering that Inuvialuit people are distinct from other Inuit who live in Nunavut or in Labrador or in northern Quebec. Those are distinct communities with distinct histories and distinct experiences of colonization. And so we're not dealing with Inuit. That's not an identity that gives you a lot of information. There's a lot of nuance across Canada. And just a few more comments to add to the conditions that you need to canvass with your client before any bail orders are in place or probation orders. Most communities have one store, it's the Northern. And so if you are dealing with an assault or a case where there's a complainant where there's going to be a non-communication or a no-go clause, if that complainant works at the Northern, your client's going to have nowhere else to go to do their shopping. So it's going to be really important that you create an exception for your client to be able to attend the store to do their shopping. Again, that with respect to the firearms prohibition, it's actually not just a matter of people's connection with the land that we want to have, people being able to do their hunting, but it's a matter of necessity and survival in a lot of the northern communities. So it's not just survival and sustenance of your client, it's your client's family, it's your client's community, because from my experience and speaking with my clients, there's a lot of sharing that goes on between very talented hunters and other goods and services that people can trade or just share and give to one another. So if you have a talented hunter in a community who's not able to go hunting that year, you're impacting the whole community. And so that's another thing that I've learned in my very brief experience here. And yeah, there are no GLADU reports, at least in the Northwest Territories communities, and it's outrageous, frankly, but it is still defense lawyers' obligations, as it's been outlined by the Supreme Court in GLADU, that we are obliged to raise those issues on behalf of our clients. And so we may need to gather a lot of that pertinent information ourselves. Or as Eva has been doing in Nunavut, pressing the envelope and putting the court on notice that that is something that we want. So shout out to Eva. I think those are all my brief overview comments.
I like it. Thank you. In this just little small section, there's just one little question, and then we'll have closing remarks shortly after that. So the second part of this is encouraging respect for legal institutions or authorities, which I think you all touched on it briefly earlier, right? It's more nuanced than what we're taught initially in law school and when we initially start practice, if we're not in a northern remote community. So in smaller communities, distrust towards larger institutions is omnipresent everywhere. What are some tools to help communicate the lawyer's roles to the client in relationship to the administration of justice, while also not triggering more trauma towards the client? Because obviously the relationship to the justice system can be, as you all noted, complex. So we'll start with Lori and then Mallory and Eva.
I think a main point that might be helpful is to help explain to the clients that even though in court the lawyer is doing all the talking, they're actually making sure that the client's voice is heard. I think that's the biggest thing that needs to be mentioned by lawyers to their clients, because when I've worked with my clients, they think that they used to think that I was promoting myself. But because as the lawyer, it's my role to argue for my client, I had to keep explaining to them that I'm actually making sure that their voice is heard. I think help them to realize that I'm there for them and not myself as the lawyer. I think that getting more people to realize that the lawyer can't have a voice without the instructions of their clients would really help to make sure that there's better respect for the work that lawyers do for their clients. I think that's the main thing that I wanted to share in response to that.
That's really important, because sometimes the client can feel unheard or not listened to if we're not telling them we're there to help them. So Mallory, do you have anything to add?
Only that I'm extremely sympathetic with my clients when they have distrust of the system, not only because of the history, but just the way our system is set up, where you have circuit counsel after circuit counsel after circuit counsel. The file gets passed from one hand to another, and clients are meeting people every couple months. Whenever the courts happening again in the community, clients are having to re-explain their story, relive the traumatic events that they're either accused of doing or suffered as part of what's happened. And memos are not perfect, and I can't completely capture my experience with the client and transfer it over to the next lawyer. So that's just the reality of the situation, but it is an aggravating feature for our clients to have to experience over and over again. And so I think being really mindful yourself and recognizing that this client is going to need more than 5 minutes in a broom closet to really open up and trust you. If you have a trial coming up, you're going to have to spend a lot of time speaking with them, getting to know what the house looks like, what their relationships look like, what this person normally behaves like. You just have to put the time in, and sometimes we don't have that either. So we can only do the best that we can, but recognizing that that is the situation for the client, and we have to try really hard to mitigate that.
Thank you. And Eva.
Yeah, I just wanted to follow up on what Mallory said and kind of talk a little bit about how from my perspective, the whole justice system and the way it operates in communities in Nunavut is not just re-traumatizing, but it sort of exemplifies everything about the way that colonialism has played out in the North. We have the court party coming in for brief periods of time, which is not dissimilar from missionaries coming in, or RCMP coming in, or teachers coming in, all of these service providers who come for short periods of time, do their work, pad up their CVs, and then get out of town and don't build those long relationships with people in the communities. And I think that legal professionals are doing the same thing. And I think it's very difficult to bridge the trust gap that is formed there. And then the other part of that is this history that is so recent. I mean, Mallory was talking about how it's people's grandparents' generation, but I have a lot of clients who were born on the land. It's not history, it's present. People's experience of colonization is their life experience. And that is manifest, or was manifest, or continues to be manifest so often through the removal of people from communities. So whether it was the removal for residential school, the removal because of TB, which is something that people who don't practice in the North might not know about that history. And then now we have the removal of people from community to serve jail sentences. And that's something that it's just the same process being played out again and again in the justice system. So of course, it's hardly surprising that there is a lack of trust in the system. And I certainly don't have any answers. I think there's the individual ways that we should work with our clients to try our best, as Mallory was saying, but I do think we also have to fight it on a more systemic level. And we have to challenge the assumptions that seem to suggest that it's okay to remove people from their home community and send them maybe to Iqaluit, or more likely to Ontario, to serve federal sentences where they'll have no support from their family, no connection to their culture. And it's frankly not okay. So in terms of building, sort of a working trust of the institution, it requires more. And I think it requires more from our government as well as from us as lawyers in terms of, changing the laws around these things. But as lawyers, of course, we can also do that by bringing challenges, which we shall continue to do.
I like that point and reminder about what we can do as lawyers. So we're into closing remarks and questions. So if individuals who want to ask questions, you can type them in, raise your hand, please. As a reminder, just to keep it to a question, because we only have a short amount of time with the panelists. And if the panelists want to add any closing remarks, they are welcome to do so. And we can go back with Lori, Mallory, and Eva. I think that was just the same one as, so if you have any closing remarks.
Naomi, do you mind if I just butt in for like 10 seconds? Just on the story, I'm going to try hard, but just on the heels of the comments by Eva, I had dropped in the chat the Truth and Reconciliation issue of the For the Defense for the CLA contains an article by Christiana Levitas and myself that chronicles the same kind of removal of NCR and unfit accused from their home communities because there are no psychiatric facilities in Nunavut. So people under the Criminal Code Review Board get detained in the South and in out of territory places. And it's the colonization impact all over again. So it's just disaster. So that's one thing. The other thing I wanted to say to those of you who are here is you've heard about the housing crisis, but it's not until you go up to Nunavut that you appreciate that some of your clients are living in converted shipping crates on the bay that frequently go up in fire. And if they don't come to court, it's maybe because they've died in such a fire living in these situations. So the severity of the housing crisis doesn't quite cover the situation, which is shameful. And you need to go up there if you can ever get up to Nunavut to appreciate the size of the communities as well. Iqaluit being the capital, but you don't have streets or numbers. It's the yellow building is where you go for your proceedings. So apart from the beauty of it all, you need to experience what your clients' lives are like if you really want to do a job of representing them. Anyway, that's just what I wanted to say. But I'm so appreciative of everything that each of our speakers has brought to tonight's discussion. I really wanted to personally thank you for what you've done here for all of us who are here and for all those many people who will be viewing the recording as well. So you'll know that you have a much broader reach beyond those who are able to join us today. Sorry, Naomi.
No, that's okay. Those are really welcome remarks.
And Naomi, if I may, just one very brief question.
Yes.
I'm just wondering how do you use, what's the use of sureties in those communities? How often does that happen that you have to ask somebody to be a surety compared to what we will see here, which is very often?
Oh, okay. Do the panelists understand the question? Okay, we'll start with Lori and then Eva and Mallory.
I think it's really very important when you're asking your clients about sureties to make sure that when you do contact the potential sureties, just how important it is to be willing to report, because that decision is such a difficult one when there's such a strong relationship. So when you contact the potential sureties, it's so important to make sure that you make it very clear just what the charges are, who the client is, and I don't know how and the two lawyers might have a better response for this, but trying to make sure that the person that is willing to be the surety because I've heard of so many sureties that when it came to deciding whether to report them, they've decided not to because they love them too much. I think becomes an enabling situation that causes more damage to the situation. So I feel like I don't have a really good response for this, but it's an important question that you've raised, because that's I think it could be a really good remedy to keep the clients out of jail, but it also has to be very carefully used to make sure that it's actually helping the client.
Eva?
Yeah, I can't speak to the frequency with which sureties are used in Nunavut as compared to other jurisdictions. I think we definitely have a lot of surety bails. One thing that's distinct is that we very rarely seem to have surety bails with a financial obligation. I think that makes sense, and I'm grateful to the court for being fairly reasonable about that. And then I think, just to pick up on what Lori was saying, one of the challenges to being a surety in these small communities is that you know that if you report your family member, that they will be removed from the community. And so the stakes are so much higher. And that again just ties back into all of the structural problems with the way that the justice system is working in such a geographically vast and culturally distinct environment. I also saw that there was a question in the chat, which I was going to try to throw an answer at, but do you want me to wait until afterwards?
You can answer it now if you like.
I don't know if I have an answer. I just wanted to throw an idea. The question was about fast tracking the process of trust building. And one idea that I have, and it's one that we don't necessarily, I can't say that we have the greatest luck with it, but the idea is that we have court workers in each of these communities who are employed by legal aid. And so they're potentially in a position to do some of the groundwork to building the trust relationships with our clients before the lawyer actually comes into town. And so, I mean, like I said, I wouldn't go so far as to say that it's working brilliantly, but it is an idea of a way to continue to deliver justice in Nunavut with a court circuit system, but potentially actually have more meaningful trust relationships. And that would be if there is, a court worker there who's able to build those relationships over long periods of time. I should just say, though, that it often also arises that the court worker becomes conflicted in one way or another, either as a complainant in a file or relative of an accused. And so it's never straightforward.
Thank you. And if the other panelists, if Mallory, you want to address it, and then we can come back to Lori for that question.
I don't think I have anything else to add. Yeah, just the court worker is an important resource, but there's more communities than there are court workers, and so that it's a benefit that you don't have all the time.
Thank you. And then Lori, so the question was, any recommendations to help build the trust with clients in a circuit style court? I guess fast tracking, or like just, I guess maybe streamlining that process when you're in and out.
That is such a difficult question, knowing how complicated the whole system is. First, like it's a mobile court system, so you only fly in once in a while, and the retention of lawyers is hard. So there's always lawyers changing, and the clients are always seeing different lawyers. They've probably been through several different lawyers before they've seen you. So I think that's why one of my recommendations was that you get trauma informed. You get understanding about Nunavut's history of colonialism and why there's such a general mistrust of the system. And it's not just a mistrust of the system. When the clients that you've gotten from their perspective, here is what they've heard all their lives, either from the governments, the churches, the RCMP, the teachers, the nurses. They've been told by all these agencies, you cannot do this. Your language does not matter. You can't raise your own kids. You can't have your own house. You can't speak your own language. You can't practice your culture. Years and years, we've started to believe it so much that we end up coping in ways that we shouldn't. Turning to substance abuse, turning to addictions, making bad lifestyle choices. So it becomes very hard to trust another lawyer that's supposed to represent you. I think that the best way to fast track it is just to be humble as the lawyer, to really take care in the clients that you're representing, because all of the individuals that you represent, plus the complainants, have been traumatized, not just as individuals, but the whole societal levels, all these communities in Nunavut. They've been forced to settle in these communities. They've been forced to live in these houses. They've been made promises that life will be better. And it's been worse for them since they started listening to these agencies. So always being humble and caring about the clients that you're representing will go a huge way to make sure that you're gaining the trust of the people that you're working for.
Thank you for those important words, Lori, and for sharing like the human aspect of all this work, that it still deeply affects. It's not just lawyer client, it's people in community and families and individuals who have their lives at stake. So I don't see any other questions. We want to take a group photo. So before everybody goes off, if we can just do a group photo.
You okay, Lori, to do that? You okay for a group photo?
We will do the group photo, and then if you want, you can ask additional questions if there's additional time, post photo. And yeah, thank you everybody for coming and making the time. It's super, we super value all your attendance.
So I put myself in charge of the picture taking. It took me the first 3 years of the pandemic to figure out how to do it without also capturing the chat and all my open tabs of online shopping. So now I think I got it. Okay, everybody, please say, how do we say thank you in Inuktitut, Lori?
There's many ways, but my favorite is nakomek.
Nakomek.
Okay, let's all say nakomek.
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 Nakomek. Nakomek.
Okay, that's screen one. We have a lot of people, so one sec. Okay, bear with me, please. This is where I get the copy of the other picture in the middle of this picture. Okay, hang on. Doing well. Hold steady for me. I feel like I'm about to take an x-ray. Everybody hold your breath. Don't blink. Okay, one more second. A lot of you are smiling who are nowhere near on my screen. I just want you to know you're smiling for nothing. But I believe I have everyone. Thank you so much for indulging me in my obsession with group photos. It's all we have when we're not in person. I really wish we had been able to do this session in person together, and hopefully we can meet again. Thank you, Naomi, for all of your incredibly hard work, and Jay as well in making this event happen. We won't bore you with the details, but it was a long road, and I think we all feel fabulous about being able to pull it together.
And Anita, I just want to thank Lori, really, everybody on the panel. But first of all, when Lori was speaking in her native tongue, I now understand what it's like, you know, because I do both prosecuting drugs and defending clients. I understand what it's like when somebody doesn't understand. That was very powerful. And Lori, the last thing that you said I think probably triggered in all of us so many different emotions. And I really thank you for that, because it brings home a lot of things about, representing Indigenous people. So thank you.
Lori, it was very powerful. Thank you for sharing that with us.
I think just as a quick final remark, there were two things that I had wanted to say. The first thing is when people talk about mental health supports, don't only recommend academically certified mental health professionals. I encourage you to ask your clients if they know of elders in their communities that can give them mental health supports, because we need to be reinforcing how important it is for communities to support each other, rather than asking them to seek yet more mental health support services that are either government provided or will only be fly-in occasional services. So I think it's important that there are strengths that exist in the communities, like mental health providers in the communities. And the final thing is that despite the circumstances that have led your clients to you, they have strengths as well. They aren't only victims of a colonial system. They aren't only perpetrators of a colonial system, but they do at some point in their lives have had assets and skills and resources that they can draw on, that that you could try and help them to realize that they can be founded on, to help make sure that they are being part of their own deterrence for future decisions. And I think it's always important just to realize that there are some strengths that can be drawn on during these difficult times. So Kuyanamik, so much for having me. I've really appreciated being part of this panel, and I hope that it's been helpful for everyone in this. These CPDs are very important, and I'm so honored to have been asked to share in my experience. Kuyanami. Nakomi.
Nakumek.
Awesome. Thank you, everybody.
Thank you very much.
Have a good night, everybody.
Good night, everyone.
Good night.